Start. In the instant case, seller was not in a position to discharge his burden and therefore he is not entitled for refund. In a review of the said position, all the authorities have held that a question of refund of tax would not arise in the case of appellant, since no tax had been demanded from the appellant for the tea. Considering the facts and circumstances of the case, tax was collected from the appellant at the time of purchase of tea in the occasion sale conducted by the tea planters, since tea is a commodity which was liable to tax at the time of first sale in the state. The tax which was collected from the appellant by the dealer has been remitted to the government by the dealer of tea. It further appears that the appellant claimed for refund of sale amount to be paid to it, despite the fact that it is not a dealer in the eye of law. Section 44 of the KGST Act is very clear and it stipulates that it is only the dealer of tea on whom the assessment has been made, and it is only he who can claim for refund of tax, and the court cannot overlook the mandate in view of the clear and unambiguous position. The appellant cannot claim for refund of tax collected from the seller of tea when the meaning and the language of a statute is clear and unambiguous. Nothing could be added to the language and the words of the statute. The findings recorded by the authorities below are clearly findings of fact and have also been arrived at on the basis of mandate of the provisions of the State Act. Therefore, the decision does not call for any interference. There is no possibility of taking a proactive stance, although it is clear that the state cannot retain the tax which is overpaid, but at the same time, such overpaid tax cannot be paid to the assessees or appellants. The principles laid down in the decision in Mafetlal's case would also not be applicable to the facts of the instant case in view of the provisions of Section 44 of the KGST Act, which refers to claim for refund and specifically states that such refund could be made only to a dealer claiming for such refund. Stop.